and their consequences by claims of accidental falls or natural events. Finally, you took his life. Only you know the reason or reasons for your actions. Not only have you deprived a young child who was resilient and exuberant of his life, you have robbed his family of the joy of bringing up a child and sharing life events with him, and caused them immense grief, the full impact of which is revealed in the moving personal statements that I have read. Reference is made to Charlie's future being stolen from him by your violent and senseless actions, which to his loving, wider family are incomprehensible. No cause can undo the harm you have caused. The sentence for murder is fixed by law and his imprisonment for life. Pursuant to Section 321 of the Sentencing Act 2020, the early release provisions will apply, and I must fix the minimum term you must serve, taking into account the seriousness of the offence, before consideration can be given to your release on licence. I apply the provisions of Section 322 of and Schedule 21.2 of the Sentencing Act 2020 in fixing the minimum term. I incorporate into the minimum term the additional culpability for the offence of cruelty, and will order the sentence for the offence of cruelty to be served concurrently with the sentence for murder, guarding against double counting of any factors and taking account of the fact that if that sentence stood alone, you would not serve the full term. The starting point for the minimum term under the Act is 15 years. However, the seriousness of the offence is considerably aggravated by the following factors. It was committed in a domestic setting in which you were in a position of trust, caring for Charlie, who was very young and particularly vulnerable, having limited communication skills, and who had suffered mentally and physically before his death. In relation to mitigating factors, although I cannot be sure you intended to kill him, you must have appreciated that the very severe degree of force used upon such a small child would inevitably have caused the gravest of injuries, if not death. Similarly, your lack of previous convictions and the fact that this was not a premeditated act can count for little, given your acts of cruelty over the preceding months. The number and gravity of the aggravating factors very significantly outweigh the mitigating factors, and there must be a substantial increase in the minimum term. The offence of child cruelty by reason of multiple incidents and the use of significant force and the serious harm caused was an offence of high culpability and Category B harm under the definitive guideline. Accordingly, the starting point is 6 years custody with a sentencing range of 4 to 8 years. It was aggravated by Charlie's particular vulnerability and limited ability to communicate. Christopher Stockton, would you stand? On count 1, the offence of murder of Charlie Greenwell, the sentence of the court is imprisonment for life. I set the minimum term you must serve as one of 25 years. To date, you have served 378 days in custody on remand. The sentence, therefore, is one of imprisonment for life with a minimum term to serve from today of 23 years and 352 days. For the offence of child cruelty, count 2, the sentence is one of 8 years imprisonment, which I order to be served concurrently. At the expiry of the minimum term, it will be for the parole board to decide if and when you should be released and the conditions to be attached to the licence. If and when you are released on licence, you will remain on licence for the rest of your life, making you liable to be recalled to prison at any time if you breach the terms of your licence and it is revoked. I order payment of the statutory surcharge in the appropriate amount. Would you take it down? In your case, Paula Roberts, there is a very detailed and helpful pre-sentence report in which the writer states that all the information available to her, including liaison with children social services, it is apparent that you prioritise your relationships over responding to the needs of your children. There is a long-standing record which highlights your inability to safeguard your children, which has led to continuous neglect in all your children's lives. This offence falls into the pattern of similar behaviour. You were aware of Charlie's injuries, but you failed to raise or act on those concerns. I take appropriate account of your having been neglected as a child. Entered into an arranged marriage when you were young, having since sought attachment from short-term relationships, and have been diagnosed with anxiety, depression, and borderline personality disorder. There is no formal psychiatric or psychological evidence. You now say Christopher Stockton was coercive and controlling your relationship, but you were quite able to dictate arrangements in relation to Charlie's father, and had long experience of the help that can be provided by service providers, and never shared your suspicions that Christopher Stockton was harming Charlie and misled others. You now recognise that you contributed to his neglect, in effect turning a blind eye to what you must have known was the reality of the situation, being in a state of denial. You remain a risk to any children in your care. There were 2 incidents of serious neglect and a failure to take any steps to protect Charlie from acts of cruelty. Reaching a fair assessment of your culpability on the guideline characteristics, I place this offence as one of medium culpability. However, your culpability is significantly aggravated by Charlie's very young age and vulnerability. He suffered physically serious harm, so this was a Category 1 offence. Some account has to be taken that by reason of your failure to act, Charlie was exposed to the risk of an event which materialised, and he died. Though, of course, I am not sentencing you for causing or allowing his death. Despite the difficulties in your earlier life and your experiences with your older children, you continue to behave in the way that you have behaved previously, prioritising yourself, and your lack of previous convictions is not a significant mitigating factor. I take into account your anxiety, depression, and borderline personality disorder. This is a specified offence for the purposes of the dangerous offender provisions, but I am satisfied that such risk as you present can be managed appropriately by a determined sentence. Had you been convicted after a trial, the sentence would have been 4 years and 6 months custody. Despite the lateness of your plea, I do afford you some limited credit for your guilty plea and remorse. Would you stand? Paula Roberts, balancing all these factors and affording you around 10% credit for your guilty plea, the sentence for the offence of cruelty is one of 4 years imprisonment. You will serve no longer than one half of that term and then be released on licence for the rest of your sentence, during which period you will be subject to being recalled to prison if you breach the terms of your licence. I will append statutory surcharge in the